Welcome to this Business Tax Roundup for this month. My name's Dean Wootten. First up, we have quite a high-profile case. It's the case concerning Stuart Barnes, the ex-international rugby player. Now, Stuart Barnes today is a freelance writer, presenter, commentator, author, etc. And he provides his services through his personal service company, S&L Barnes Limited. And he provides it to various outlets. Now, this case concerned Mr. Barnes's work for Sky through his personal service company. The parties agreed an initial 4-year contract, and then there was a second-year contract after that, potentially. Now, £235,000 was paid for up to 228 days of work in any given year, and this was broken down into 12 months and paid monthly. But it's up to 228 days of work. Stuart Barnes undertook preparatory work and rehearsals, commentary, and various interviews. If he was unavailable, Sky, not the personal service company, Sky would choose another pundit to take his place. Now, Sky had full editorial control over programmes. Stuart Barnes was subject to Ofcom guidelines. Sky provided all the necessary studio equipment. Sky made the necessary travel, accommodation bookings, reimbursing reasonable expenses, etc. Now, Stuart Barnes assigned all the intellectual property rights and copyrights to Sky, and they had exclusive rights to commercially exploit the work that he did for them. Now, Mr. Barnes agreed not to undertake other broadcasting or media assignments that breached his non-compete clause. And the assessments under IR35 were some £695,000. They would also be reduced by the amount of tax the company paid, but it's quite a high-profile number, £695,000. Now, the first year looked at the hypothetical contract between Stuart Barnes and Sky. And they applied the 3-stage test, mutuality, control, substitution, from the ready-mix concrete case. Initially, now, mutuality of obligation was not disputed. Yes, Sky was required to pay Stuart Barnes a fixed monthly fee over the period of the contract, and he was obliged to provide those services. Sky had overall control over the date, location, timing of his work. You had Ofcom rules, editorial guidelines, and the programme's producer controlling the content. There were warranties, non-solicitation and non-disclosure clauses assigning rights to Sky. But you've got to look beyond that. So yes, you look at the framework contract. Yes, you look at the mutuality, control, substitution. There's obviously no substitution in this event. But you look beyond that. And if the other factors are strong, then you may well get away with IR35. Now, Stuart Barnes worked less than half of the maximum stated term in his contract, or days in his contract. Now, the first year viewed the money paid as a block fee for first call on his time. It wasn't a salary. He worked for many, many organisations. Only 60% of his income came from Sky. He was not financially dependent on Sky. At the end of his second contract, he refused a new contract with Sky. He could walk away. He had many other options. Stuart Barnes was unavailable during the Six Nations season and the World Cup, but he could be asked for pre-match interviews if he was around. So he's very much in control of his own destiny to an extent. Now, without Sky's contracts, he would have found other media-related work. He published his views for other media organisations. Sky actually quite liked that, because it just promoted his standing in the game. So as far as the first year is concerned, he was in business on his own account, and the appeal was dismissed. There are 3 previous cases which went the other way, and I think HMRC were quite confident that this case would go the same way as the previous 3. But I think because Mr. Barnes had quite a high profile, quite a high brand, and he had lots of other outlets for his time, for his expertise, he was really in business on his own account. So it's not just the contract itself. You've got to look at the bigger picture. And the more clients you have, the more financially independent you are, then the more likely you are to be outside of IR35. We'll now look at a case concerning personal liability notices, i.e. the ability for HMRC to shift a penalty from the corporate to the individual if there's a deliberate inaccuracy. Now, Colm Malone traded as a sole trader and then 2 partnerships. He had to provide security because he had unpaid VAT and surcharges in his previous companies, etc. Now, the second partnership became insolvent, owning VAT and surcharges. Now, business then continued as a newly formed company, with Mr Malone as sole director and shareholder. HMRC, obviously being a bit wary of his trading concerns, they visited the premises twice, concluding that takings did not match those declared for tax, so takings were higher. So the company was issued with assessments, and they estimated the corporation tax bill, the VAT bill, etc., for undeclared income, and penalties for not declaring the full income. Now, with the business like to become insolvent, HMRC issued Mr Malone with personal liability notices for the VAT and corporation tax penalties. In the end, these amounted to about £54,000, shifting from the corporate to the individual. The actual tax doesn't shift, but the penalties can, if HMRC are successful with their personal liability notices. And to be successful, they've got to prove that the errors were Mr Malone's fault. He deliberately understated income. Now, shortly after, the company was placed in a creditor's voluntary liquidation. Mr Malone appealed against the personal liability notices, because he argued the inaccuracies were not deliberate. There's no appeal against the assessments and penalties by the company or its liquidator. I'm presuming that there wasn't the means to pay, so why appeal? Now, the tribunal agreed with HMRC that the company deliberately concealed information, records, etc., leading to inaccurate VAT and corporation tax returns. Those returns were provided knowing they were wrong. And with the deliberate inaccuracies attributable to Mr Malone, the only director, etc., then the personal liability notices were upheld, and the £54,000 worth of penalties shifted to Mr Malone. So it's another case where, if there's wrongdoing in the company, then okay, you can walk away from the corporation tax and the VAT, but the penalties can follow any individual responsible for those inaccuracies. In this case, just Mr Malone. Let's look at some VAT, some important VAT cases this month. First one is Morrison's, the supermarkets, and it's an odd case in many respects because when you see these liability cases taken, they're not normally taken by the supermarket, but this one was. It was taken by Morrison's. And they argued that the naked bars and organics bars were zero-rated food, and they were seeking a refund of the overcharged VAT. They'd accounted for output tax on these bars, and they thought they were zero-rated. Presumably, though, the manufacturer had charged them VAT on those bars, so if there was any refund of output tax, then presumably there would have been an adjustment of input tax that they've claimed. Now, HMRC reviews the claim, and Morrison's appealed. Now, the first tier found in HMRC's favour. The bars didn't look like cakes. I mean, cakes are zero-rated. They were marketed as snacks rather than cakes, and they would have looked out of place on a plate of cakes. They seem to be emphasising that these were cakes, or the client was arguing that they were cakes and not confectionery. Now, the case moved to the upper tribunal. Now, the upper tribunal found that the first tier tribunal had erred in law, and I guess this is the important thing from this case. The first tier finding that the product's healthiness and its marketing was irrelevant to their decision as to whether the products were confectionery or not. I think marketing is quite important to what these products are. Failing to consider the absence of traditional confectionery ingredients used in bars, such as cane sugar, butter and flour. So the upper tribunal was saying, well, the first tier has not done that great a job here. They've not looked at factors that we consider to be very, very important. Now, had these been taken into account, the first tier might have reached a different conclusion. Without the full facts in front of them, the upper tribunal remitted the case back to the first tier, and they said it should be heard by a newly constituted tribunal to be selected by the first tier president. And they may have access to recordings and transcripts of the original hearing. Now, the additional findings and facts must be based on the evidence before the original first tier, and if relevant, the new tribunal's own taste test of the product samples. So the upper tribunal are not saying these are definitely not confectionery. What they're saying is the argument or the approach taken by the first tier is not the correct way to do it. So it may be that these things end up as confectionery, but you've got to go through the right process. and you've got to look at ingredients, how they're marketed, etc. Let's look at a case on default surcharge and the impact of COVID-19. Now, the company Abista Property Interiors fitted kitchens and bathrooms, and they began trading in August 19, quite an unfortunate time to start trading. Now, VAT was paid late for all periods between July 20 and October 21. Not that late. Yeah, most returns were late during that period, and they were right up to the 15% default surcharge in the end. Now, the company argued that lack of funds caused by COVID-19 were a reasonable excuse. So I would think this is quite relevant for a lot of businesses that were struggling, and maybe still are struggling, by the after effects of COVID-19. Now, COVID caused loss of revenue and having to wait for revenue far longer than normal. Projects would start, but poor availability of products, which is a fair point, would delay the project. And a delayed project is delayed income. The job went on for 2 or 3 times longer than the normal time it was expected due to isolating staff or clients. So there was a double factor, really. The project was taking longer because of struggling to get hold of materials, and then you had the other side of it with isolating staff and or clients. Now, as a new business, the company is not eligible for COVID-19 related government grants, so there's no help for them. To avoid mortgage defaults and to enable food to be bought, the company paid staff and suppliers over HMRC. So HMRC were the last organisation to be paid. Now, taxpayer pointed out that HMRC had extended the self-assessment fine deadline by a month, but the longest HMRC had to wait for this company to make their VAT payments was 17 days. They weren't that late. HMRC had their own issues at that time. They made several attempts to call HMRC during the relevant period, but you just couldn't get through to them, presumably shortage at HMRC's end in terms of staff. So what did the court hold? Well, they held that the staff and customers isolating, driver shortages and lack of government support for the new company had been all factors in their 17 days late payments. Now, normally it's not appropriate for a taxpayer to take matters into their own hands, but in these circumstances it was acceptable. Yeah, they almost, like they were saying, they should have paid their staff first rather than HMRC, which is fair enough. Now, since COVID-19, the company has kept fully up to date with its VAT obligations. So on balance, the company's actions were objectively reasonable, and the failures were remedied without unreasonable delay. I think that 17 days is probably quite important here. If it was 3-4 months, then it may well have been a different result. So in the end, the appeal was allowed. So there were some COVID-related factors. They'd done their best, and that was held to be dealing with a very, very difficult situation. So a reasonable excuse, and the default surcharges did not stand. Quite an important case on consultancy services for VAT, Gray & Farrer. Gray & Farrer are a very upmarket dating agency, and the fees are somewhere between the annual fees 20,000 and 115, 120,000, something like that. It's very upmarket. It's obviously for very wealthy people. Now, the basic place supply for B2B services is where the customer belongs. So if you're billing B2B and the customer belongs overseas, that's outside the scope. The basic rule for B2C services is where the supplier belongs. And if the supplier belongs in the UK, then VAT is normally chargeable if it's taxable. There are, however, a few overrides to the basic B2C and B2B rules. This case concerns one of the B2C overrides. Now, Schedule 4A, Para 16, contains the Para 16 B2C override. Now, Para 16 lists a bunch of services, and one of those services is consultancy services. Now, Para 16 services, when supplied to non-EU customers before 1st of January 21, were outside the scope of UK VAT. They were supplied where the recipient belongs. Now, from the 1st of January 21, this was extended to consumers outside the UK. So in current day terms, if it's B2C, a Para 16 service, so consultants, lawyers, accountants, and you're billing somebody that lives outside the UK, then there's no VAT, because it's supplied where the recipient belongs. Now, this case is all about consultancy services. What are consultancy services? Now, consultancy services are for the provision of information and expert advice. Now, the first tier found that the dating agency fees went beyond consultancy fees. And the 20,000 fee or upwards was therefore standard rated because it remained a B2C service. The Upper Tribunal reversed this, and they thought Graham Farrar were providing information and expert advice. So they did think Paris 16 applied. But the Court of Appeal has just reinstated the first tier decision. And they stated that the services Graham Farrar provided were not principally and habitually provided by consultants. Now, to my mind, that's not very helpful, because what are typical consultants? Are they, well, yes, management consultants for sure, but does sticking consultants in your business name mean you're consultants? So I don't think this is a very useful statement, principally and habitually provided by consultants. Now, when you actually look at what Graham Farrar provide, to my mind, it is information and expert advice. It's not your typical dating agency, this one. They are very hands-on, and they are, in my opinion, providing information and, more importantly, expert advice. Okay, in a field that you wouldn't normally expect, but that shouldn't mean that you're not able to get the consultancy label. So this may well be appealed, because it does, to me, seem appealable in terms of the decision. Let's now look at the input tax incurred on trying to raise funds for further acquisitions. And this case related to the flotation of Gordon Dad's Group Limited on the AIM and the simultaneous raising of 20 million for further acquisitions. Now, this was effected using a reverse takeover in which the Work Group PLC acquired the Gordon Dad's Group Limited with Work Group joining the VAT Group on that same day. Now, Work Group received and paid for services in relation to the takeover and further acquisitions. And they sought, via the VAT Group member, to recover the input tax. Now, HMRC denied that, and they said, well, Work Group, who's incurred the VAT, they themselves intend to make any taxable supplies. So how can you attribute it elsewhere? Now, the group appealed, and they argued that the supplies were to the VAT Group member. So because Work Group were part of the VAT Group, they said, well, the VAT Group is one person, so therefore the supplies were to the group member, and the VAT Group representative was carry on the taxable activity of the group as a whole. So they kind of regard it as one person, input tax, and it's almost like it doesn't matter who the input tax comes into if you're in a VAT Group. Now, first they looked at this and they said, well, they joined the VAT Group and incurred costs for the purpose of raising funds. The funds were to be used to make acquisitions that would benefit from the VAT Group's members' management services. So there is an indirect link between the input tax and the ultimate supplies, but the use of the funds did not result in a direct immediate link between the costs incurred by WG and the management services supplied by the VAT Group rep member. You had to look at the company itself. WG incurred the input tax, and WG had no taxable intent in itself, so therefore the input tax was not deductible. So I think this is just a learning case, really, because if you want to recover input tax, then you've got to have taxable intent yourself. You can't look at, if you're in a VAT Group, according to this case, at the VAT Group's intent. You've got to look at the company incurring and say, well, what is your intent? And if it's taxable, fine. If it's not taxable, i.e. this company is pretty much dormant, then you're not going to get the input tax back. Well, that concludes the Business Tax Roundup for this month. My name's Dean Wootten. Thank you for listening.